Monday, November 15, 2021. What we are discussing today is going to be child support. So I am sharing my screen with you. Hopefully you are seeing my PowerPoint. And let's take it from the beginning. Let's start here and let's go through it. Again, this is child support. We're going to talk about it because you will see something about either child support or child custody on the final exam, and there's a good chance you might see something about it on the UBE. When we get to the custody piece, we're going to talk in terms of physical custody, legal custody, because that is what is going to be tested on the UBE. If you're interested in practicing law in the state of Texas, then let's have a conversation, right? Let me know. We'll chat about it. I'll tell you more about it. But until then, we are talking in terms of UBE. Let's get started. See if I can get my screen to move. Child support defined, very easy definition, specific amount of money paid by one party to another party at specific intervals, generally monthly, for the benefit of and for the assistance in supporting the living expenses of the child. Don't get so narrowly focused to allow your logical, rational minds to think if child support payments are for the benefit of the child and or are for the benefit of supporting the living expenses for the child, that every penny of the child support has to be somehow connected to, rationally related to, or causally next to something direct for the benefit of the child. That's not how it works, right? It's understood that the support is a payment. The support goes into this pool of resources that is accessible to the parent who has physical custody of the child. And from that pool, the parent can make financial decisions. So don't get lost. Don't allow your friends to get lost. Don't allow your clients to get lost in this fictive notion that I'm paying child support, but the parent's driving around in a Porsche. So what? If you order to pay the child support, pay the child support. Duty to pay child support is on both parents. Stop, take a breath. What I'm saying is, as a parent, mom and dad, mom and mom, dad and dad, whoever the two identified parents are, both have an equal responsibility to meet the financial needs of their children. Then why does one pay child support to the other one? Because usually one actually has physical custody of the child more than the other. So again, this is not going to be something that you're going to be able to logically or rationally explain. It's just the way that it works. It works in equity, but as far as both parents' duty, they both have a duty to support the child equally, okay? However, generally one parent winds up paying child support to the other parent. Agreed orders. Can the two parents enter into an agreement regarding the amount of child support? Yes, and that's preferable. No judge under any circumstance wants to use their courtroom as a platform for people who have participated in a very intimate act of breathing into creation a new life, sit there and talk horribly about each other. It might be great drama for TV, but in real life circumstances, real life situations, it's not the best way to provide for a supportive environment for two parents to jointly work together for the benefit of the child, even when they're living separately. So, yes, parties can reach an agreement regarding child support. However, no matter what the parties agree, the court is not bound. The court's primary focus is what's in the child's best interest. That's all judges care about. And while the judge may have an opinion, and while the Constitution does not allow the court to substitute or act as parents patriae to make decisions, the court does have the duty to make sure that regardless of what the parents might agree to, the child is taken care of, okay? Child support is independent from visitation. If you don't get visitation, you are not excused from paying child support. Say it one more time, I'll say it really slow. Just because the parent who has physical custody of the child may be a boogerhead about allowing the obligor to visit, the obligor cannot use the boogerhead tactics of the parent that's not allowing visitation to justify the non-payment of support. Two independent covenants. So you remember that from contracts. Guidelines for support. Every state has presumptive guidelines. We will not get into the details of those presumptive guidelines because 10th Amendment, every state has a different guideline, right? For instance, Texas looks at the income or the net resources of the obligor. That's the person who's paying the support. Texas does not take into consideration the assets of the obligee. That's the person who's receiving the child support. Some states do, okay? So we're not going to get into those details. Suffice it to say that every state has a presumptive guideline of how child support should be determined, the amount. If you're interested in Texas guidelines for support, here's some links. Feel free to go to them. One is just determining general child support in general. One is the child support calculator. One contains the actual presumptive guidelines. One's a handbook. This is the Texas presumptive child support guideline if you are interested in Texas, right? If you're interested. The STARS 1256.67 for monthly gross is the monthly gross based upon minimum wage, 40 hours a week, okay? Texas takes the gross, deducts Social Security tax, deducts Medicare tax. Those two taxes are considered payroll taxes. Those are the taxes that your employer withholds, whether you like it or not. Allows for income tax for one party, right? And what's left is your net income. Texas uses a formula to take a certain percentage of your monthly net, that's child support. People spend lots of money getting child support, defending child support. People get lots of money arguing about the dollars and cents of child support. I was an attorney, I did family law, made a great living, had lots of child support cases, because if you can pay, I will be happy to argue the principle. But child support really is one of the easiest things to establish because literally for Texas, it's a mathematical calculation. Look at the numbers. It's really pretty simple. Percentages for child support for Texas, if you're interested. One child, 15% of net resources, 2 children, 20%, 3 children, 25%, 4 children, 30%, 5 children, 35%, 6 or more children, not less than 35%, maybe more than, but not less than, right? Child support guidelines are a minimum, right? So there may be lots of different reasons why you would be entitled to more than guideline. The guideline is the minimum, okay? When does child support obligations decrease or terminate? When the child dies, when the child is emancipated, or upon termination of the parent's rights. When does a child support obligation cease? When the child dies, when the child is emancipated, or upon termination of parental rights. What is emancipation? Emancipation can be one of several things. You can have judicial emancipation, where a minor petitions the court to remove the disability of minorhood and judicially pronounce that the child is now emancipated, right? Or generally, when the child reaches the age of majority, which for most states is 18, or when the child graduates from high school, which means if the child is 18, let's say January of the year, but doesn't graduate from high school until, let's say, May of the year, the obligor would be obligated to continue child support payment until the 18-year-old, technically still a child, graduates from high school. Okay. Another way for a child to be emancipated is marriage before the age of 18 or before the age of majority, or entry into the military before the age of majority. Full faith and credit applies to child support orders, just like anything else. Continuing exclusive jurisdiction, take a quick look one more time, look quickly once again. We'll come back to it, okay? Child support obligations are not dischargeable under bankruptcy. Child support obligations are not dischargeable in death. With what? I'm obligated to pay child support and I die and I'm still obligated to pay child support? Sure. If the child support order is still valid, if you were alive, well, how do you get child support out of a dead person? Think about it. You file a claim, right? You file a claim and it becomes an obligation of the deceased estate, or let's do it this way, of the estate of the deceased, right? Okay. Can child support obligations be modified? Sure. What do you have to establish? That there's a substantial change in circumstance of either the child or one of the parties. And here's a conjunctive rule. And here is a conjunctive rule. Both of these prongs have to be satisfied. A substantial change in circumstance and the requested modification is in the best interest of the child. Okay. We talked about UIFSA last class period. That's the Uniform Interstate Family Support Act. We talked about UIFSA because UIFSA can serve as a way that forum courts can obtain jurisdiction over an absent parent. Because for child support provisions, the court must have subject matter jurisdiction and in personam jurisdiction over both parties. Yeah, distinguishable from forum court jurisdiction for divorce. Remember, forum court jurisdiction for divorce only needs jurisdiction in personam, personal jurisdiction over the petitioner, right? And through the personal jurisdiction of the petitioner, the court can obtain subject matter jurisdiction over the marital status AKA in res, RES jurisdiction, meaning that a forum court can grant a divorce without personal jurisdiction over an absent defendant. It's very different when we start talking about child stuff, children's stuff related to children, right? Very different. Got to have subject matter and personal jurisdiction over both parties. Not going to take a lot of time rediscussing Parker v. Alaska Department of Revenue. We talked about this on Wednesday, spent a lot of time on it. This is the state's statutory long arm statute that allows a forum state to reach through the long arm of the law and pull that non-resident, what would be absent defendant, back to the jurisdiction for personal jurisdiction reasons to establish child support. We talked about it, right? All I did here was just re-include the slides that we already discussed. So I'm going through them slowly, but you have this PowerPoint. You can pull this up at any time. You were in class. That was a live lecture. You took notes. We asked questions. All I did here was just cut, paste, insert so that there would be a logical progression of the conversation under child support. Didn't add anything, didn't do anything differently, okay? We then get to UISFA, the Uniform Interstate Family Support Act, which is akin to a uniform, not a state statutory, but a uniform long arm jurisdiction statute, in that the forum state asks the state where the defendant is a resident to take up the child support matter, okay? That's the Department of Human Services v. Leifster. We spent a lot of time walking slowly through this on Wednesday, step by step. I've just duplicated the slides here. If you're unsure about any of this, look at the PowerPoint from Wednesday last week. Look at your notes, walk it through, think it through. If you don't get resolved, contact me, we'll discuss it. Okay. Done with the introduction, child support general, done with jurisdiction for child support orders. Let's talk about best interest. Okay, we talked about this last week as well. This is the Holly v. Adams case. Went up to the Supreme Court. Doesn't matter what jurisdiction you're in. If it's related to a child, that is custody, visitation, child support, medical support, the court is always led by the best interest standard, right? Highlighting some of the facts from Holly v. Adams. Again, we discussed it. I'm just going through these slowly. Didn't add anything, didn't change anything. Again, just reinserted this here so that we could have a logical progression about child support. Ultimately, because this is not a conjunctive rule, there is no and, because this is not a disjunctive rule, there is no either or neither nor, right? This is a factors rule. These are the factors to be considered. If you take a moment, look at these factors, they're common sense factors. Don't use your bandwidth to try to memorize these factors. Look at them Realize these are common sense kind of factors. So allow yourself the freedom to have the confidence to argue common sense factors if you're having to argue a child-related matter. Okay? Disregard that. That's just a train going by. Let's talk about, how do you determine the amount of child support? We talked about those presumptive guidelines. The Pops v. Gardner case of 1993 is a presumptive guideline case. What am I saying? Parents opposed to punitive support filed a lawsuit saying that the state of Washington adopted by legislation presumptive guidelines. And this group of parents who were non-custodial parents, that means the people who didn't have physical custody of the children, that means the people who were ordered to pay child support, brought this class action suit because they were arguing that the presumptive guidelines violated the Due Process Clause of the 14th Amendment and the Equal Protection Clause of the 14th Amendment. What's the short story of this case? Here's the short story. The law that established the presumptive guidelines made it clear that the court has discretion to deviate from those presumptive guidelines, so long as the court expresses in writing its findings that support the deviation, right? So it's like any other legal presumption. Legal presumptions are rebuttable, as is this child support guideline. So specifically, what was the argument? Specifically, the parent group said that the law violated the Due Process Clause of the 14th Amendment and the Equal Protection Clause of the 14th Amendment because the presumptions were a one-size-fits-all mathematical calculation, and every child doesn't fit into that one-size-fits-all scenario. For instance, let's say my kids are eaters, and let's say my kids actually eat $50 a month worth of food, right? And let's say that the presumptive guideline takes into consideration that the average child eats $50 a month in food. Based upon that presumptive guideline, the number that I get to using the guideline is going to assume that the proportion of that amount for food is going to be $50 because that's what the average kid eats. What if you come in and say, well, my kid doesn't eat that much. My kid only eats $10 a month in food. The parental group is saying, for those kids who eat less, now understand, guys, this is an analogy. I'm using this as an example. This is not what they were literally arguing, but I'm explaining to you through this example what they're arguing. Pops is saying that if my kid only eats, my particular kid, my uniquely situated kid, only eats $10 a month in food, but you are assigning an amount for me to pay that presumes that the kid eats $50 a month in food. In essence, what you're doing is ordering me to overpay. Get it? Yeah, take a second, think about it. And because you're ordering me to overpay, what's happening as a result of that is you are jacking with my opportunity to get married to somebody else, because who wants to marry a person who's paying child support for a child from some other relationship? So what are they saying? Come on, guys, you know it. What are they saying? Pops is saying this presumptive child support calculation is interfering with my right to marry. Oh my God, do you remember? Remember? Loving v. Virginia, we talked about individual rights. See how all of this, it's the foundation for everything we do, right? And because you don't, court, legislature, identify how you came up with these presumptive numbers, technically, I can't rebut these numbers. So in essence, you are preventing me from my procedural due process rights, right? To actually adequately be heard. Oh my gosh, get it? Yeah, right. Are you thinking, oh my God, the light bulb is on. This makes so much sense. In essence, the court said, look, guys, we are not doing anything by any stretch of the imagination that's interfering with your fundamental right to marry. And if for some reason you paying child support for a child that you brought into this world based upon these presumptive guidelines is so limiting on your individual specific right to marry, tell that to the court, because the court has the discretion to deviate from the guideline. And I said, okay, well, how about this? How about the guidelines are violating the equal protection of my non-custodial parents' later children, right? So really what you're saying is, by forcing me to pay this, they want to call arbitrary amount of support to this kid over here, you're literally taking money out of the mouths of any other children that I may have. And so these other children that I may have are now being classified in such a way that they are being disadvantaged. The court said, come on, guys. Children that the obligor may later have are not a suspect class. There is nothing suspicious about children that you're paying support for in this case versus other children that you might have to pay support for. This is not an equal protection violation. Court went on to say, throwing a little shade, if you want to say that later children are going to be so disadvantaged because you are ordered to pay support for another child that you brought into this world, then maybe you need to make better decisions. If you read the case, that's ultimately what the court said. So once everything was said and done, the court denied the allegation that the presumptive guidelines violated due process, and the court denied that presumptive guidelines violated equal protection. So ultimately, what does all of that mean? States have their presumptive guidelines. They're going to calculate support. If you or your client believes that that support is somehow egregious, make the argument. If you can't make the argument, pay the support. Got it? Nice. How do you enforce child support? Well, there's lots of ways. You can be held in civil contempt, which means you can go to jail on civil contempt. You can be held in criminal contempt. You can be denied in Texas a gun license. In lots of other states, you can be denied your driver's license. You can be denied the ability to renew your licenses. You can be denied the right to exercise Your professional licenses, yeah, lots of attorneys graduated from law school, paid the bar, who had a child support arrears, who couldn't get their license until they brought current their arrears. It's a financial obligation that you're not supposed to be able to minimize or negate or subjugate to something that you'd prefer to spend your money on. State v. Oakley, short review of this case. Dad made an argument that a condition of probation that prohibited him from bearing more children or producing more children until he could show that he could financially support the 9 children that he had, that he habitually didn't support. So argued Dad, was a violation of his 14th Amendment right, which one? Substantive right to procreate, right? Essentially, Dad has 9 kids, habitually refused to pay child support. Been to court lots of times, held in contempt lots of times, gone to jail a few times, still not paying child support. Back in court, entered a couple of pleas. Court's really pissed off at this point. Even with the pleas, the state is asking that Dad serve 6 years in jail. Dad said, put me on probation, let me get a job, let me work, let me pay some support. The court said, I don't believe you. You hadn't paid support. I don't believe you're gonna pay support. I'd love to put you in jail, but here's a reality. If I put you in jail, you're really not gonna be able to pay support. So what we're gonna do is put you on probation. However, one of the conditions of probation is you can't have any more kids. No more kids until you show this court that you can be financially responsible for the new kids and the kids that you currently have. Dad said, foul. You are interfering with my fundamental constitutionally protected right to procreate. Short story, court said, not at all. Your right to procreate is not being eliminated. It's not like the case that we talked about where the state was seeking sterilization, right? This isn't that case. This is get your stuff together, be financially responsible, support the children that you brought into the world before you bring in more children. The minute you do that, you can have as many children as you want. So there is no violation of your substantive constitutionally protected right to procreate. Questions? Enforcement? Pretty easy, right? What's another way to enforce child support? Wage withholding orders. What's another way to enforce child support? You lose your IRS refund. All of those things are appropriate and have been legally tested as within bounds when it comes to enforcing child support obligations. Questions? Take a minute, think about it, write them down. You good? All right, let's move on. Motion to modify. Can you file a motion to modify child support? Sure. Again, what do you have to establish? Substantial change in circumstances and requested modifications in the best interest of the child. What are some of the factors to be considered when looking at modification and as to whether or not there's the change in the circumstance and if it's in the child's best interest? I've listed some of them there. Those are not exhaustive. Let's talk about Olmstead v. Ziegler. Short case, parents married, parents had a kid, parents divorced. Both parents are lawyers. Dad's making $53,000 a year at the time of the divorce as a lawyer. Come on, guys, this is 89. That's good money. Mom was making $25,000 a year as a lawyer. Couple of years later, mom starts working at a firm. Mom's now making $53,000. Dad's now making $10,000. Wait, what? Yeah, $10,000. Hold on, it gets better. Next couple of years, he's making $13,000. What the, right? Wait, right. Right. I mean, so what happened? This is what happens. Dad had a partner. Dad's partner left him and said, dude, you sit at work, you play video games and computer games, and you're not interested in practicing law clearly. I'm out. Dad didn't keep regular office hours at work. Dad stopped advertising. Dad stopped essentially working. Dad decreased his client base. Dad eventually says, you know what? I really don't have the personality to be successful as a lawyer. I'm going to go back to school, get a teaching certificate, and I'm going to teach. So I'm going to file a motion to decrease my child support obligation, and the judge is going to sign it. And wait for it. Court says no. No modification. Dad says, wait. I'm not asking for a decreased order for child support because I'm going to be a student and because I'm going to be a teacher, right? I'm not doing that. I'm saying decrease my child support obligation because as a lawyer, I went from making 50 plus to barely making 11.5 on average, right? Judge says, check this out. Doesn't really matter to us what you want to do. You can be a lawyer, you can be a baker, a candle shoemaker, or whatever that Disney or Mother Goose rhyme is. We really don't care. But you have the capacity to earn this amount of money. Whoa, what is the court doing? The court, in essence, is imputing income. What do you mean by, wait, hold on. Okay, no problem, I can slow down. The court is taking into consideration the amount of money that dad can make. And we know how much money dad can make because dad's made that amount of money. Now, dad doesn't have to be enslaved in this profession that he hates or that he feels is not who he really is. But the child is not going to bear the hardship of the grown people's decisions. And so, because we know that you can make $50,000+, and because we know that you've done some things voluntarily, intentionally, that has allowed that to be decreased consistently over the last few years by $40,000+, you don't get to come in here and ask for support based upon your lack of motivation. We find that what you've done is that you've intentionally underemployed yourself. We're going to impute the income that we know that you can make to you, and your child support obligation stays the same, right? So when you're looking for modifications and when you're trying to determine whether or not someone is underemploying themselves, that is, if you're looking for modifications downward, and you're trying to determine if someone has underemployed themselves, step one, you look at the nature of the change. Step two, you look at the reason for the change. Step three, you ask, does the decrease in financial support to the household where the child lives serve the best interest of the child? In my practice, I have learned that modifications upward, I can't think of one that I haven't received, that I've asked for. Modifications downward, I'm smart enough not to take those cases, because very rarely are you able to argue in good faith as an officer of the court that even a penny less to the household that supports that child is somehow going to better serve that child. Questions? Nope. Think about it. I'm going to stop sharing my screen. Going once, going twice. If you have questions, write them down, email them to me, text me, reach out to me, or add them to your list of things to review so that when we review on the 22nd, all your questions can be answered. But again, the only reason you wait to get clarification, confirmation, affirmation, or an answer is if you choose to, because otherwise, all you have to do is reach out to me. That was the lecture for Monday, November 15th, child support. Talk to you soon. Bye.